Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we've got a twofer. We're talking about two people the United States is involved with when it comes to spying issues. Julian Assange of WikiLeaks and a former CIA official, a computer programmer who pled guilty today to stealing classified documents, and we'll cover that. So we're going to cover the story of Julian Assange. Julian Assange was the head of WikiLeaks, which is a well-known organization that leaks documents people don't want to have leaked. And he has been wanted by the United States for some time relating to various charges. We'll get into that a little bit later. And he was very famously for a very, very long time inside the embassy of Ecuador. Well, for whatever reasons Ecuador might make such decisions, Ecuador decided to allow the UK police to enter its embassy in order to arrest Assange, which is perfectly fine. It should be perfectly fine anyways. They want to waive their diplomatic immunity as to their consulate. That's fine. So they come in and arrest him, and now he's inside the UK. And now the US, of course, wants to extradite him to the US. And it appears now that the Foreign Secretary, which is our equivalent of Secretary of State, has said yes. And now the only questions that could possibly bar this are apparently legal. But let's go ahead and get into this article and see what this article has to say. The UK, at least as to its political apparatuses, has approved the extradition of Julian Assange to the US to face charges within the United States. Assange is wanted by the United States with respect to publication of thousands of classified military documents, and it was approved by the UK Home Secretary, which is the equivalent, well, actually, no, the Foreign Secretary would be the equivalent of the Secretary of State. I'm not sure what the Home Secretary would be the equivalent of, but something on that order of magnitude, I guess. And there are numerous appeals, obviously, that are available. But all things being equal, I would imagine this extradition to go through one way or another. We'll see. The deportation was approved Friday by the Home Secretary, following a series of failed legal battles in British courts. So the courts have already spoken to this to some degree. And then, of course, there's ultimately a political question at the end of the day because he's within the jurisdiction of the UK. And so the UK ultimately has to make a political decision about whether it wants to or not because it's a sovereign entity, just like the United States. Now, that being the case, however, there are treaties that somewhat curtail their decision-making, but still there are some potential options there. Assange is won by the United States on 18 counts. Some of these, I believe I know what they are because I've read some of his indictments. I don't know if I've read all of them, including spying charges relating to the WikiLeaks and the vast troves of confidential information. On June 17th, following consideration by Magistrate Court and the High Court, the extradition of Assange to the United States was ordered. Assange retains the normal right to appeal, so there are some legal options of appeal in case there is issues of law. In this case, the UK courts have not found it would be oppressive, unjust, or abusive process to extradite Assange, nor have they found that the extradition would be incompatible with human rights, including his right to fair trial and freedom of expression, and that while in the United States, he'll be treated appropriately as according to his health. This all seems basically proper and in keeping with U.S. law. So let me talk a little bit about some of the charges that Assange is facing. And I don't really have a particularly strong position at this time as to whether Assange is guilty or not of any of these charges because the amount of information that's available, or at least the amount of information I've personally reviewed that's available, does not lead me to the position of being able to say that the U.S. government's case is particularly strong. It might be, but I don't know. It seems a little bit odd. So some of these charges seem a little bit more suspect than others. The charges I've read fall into two groups of categories so far. There is solicitation with respect to classified material and solicitation with respect to Chelsea, also known as Bradley Manning. So let's discuss those in turn. Okay, WikiLeaks, of course, runs a very famous website dealing with leaking information. Here's the law as it relates. Under the law as it currently develops, a journalist is not responsible for leaking classified information unto itself. A journalist, well, unless they themselves have a security clearance, but how would that happen? So anyways, I suppose they could obtain it directly from the government in some sort of capacity. So, all right. So if a journalist obtains the information directly from the government with some sort of non-disclosure agreement, then we're in an entirely different ballpark, right? This would be information we're going to be receiving from a third party. Let's simplify it, okay? So if you're a journalist in the United States and you want to release classified information that you obtained from a third party, right? So you're not the one with the security clearance. You've not obtained the information directly from the government as pursuant to some sort of agreement, non-disclosure or otherwise. You're obtaining it from a random third party. The relevant law in the United States is that this is legal, right? It may be illegal for the person who's providing the information to you because they're violating their obligations because they were given the information pursuant to law, right? And they were given the information with certain security clearances in place. So, for example, if you're considering the case of someone like Edward Snowden, for example, right? Whatever you might think about it on moral terms, Edward Snowden is almost certainly guilty of any number of violations of the National Security Act because he himself was in a position where he received the information from the U.S. government pursuant to law. He was required as part of the receipt of that information to keep it secret. He did not. He released it without authorization, without being authorized under law. Now, one could argue that he did a good moral thing, and if you want to say that he did a good moral thing in releasing the information, then, fine, there's a moral calculus to be had there. And I'm not here to tell you about how you should feel about things morally. I'm here to tell you about the law. And under the law, he was subject to the National Security Act. He obtained the information pursuant to the National Security Act. He leaked the information in violation of the National Security Act. He's almost certainly guilty of any number of National Security Act violations. It's a little bit hard to say how he could not be. Just based on the nature of his position and based on the nature of how he obtained the information and the nature of how he released the information to people not authorized, he's almost certainly guilty. Right, his guilt would ultimately have to be proven in the court of law, but the information that's available allows us to at least see that this is quite prudent. And his defenses that he's offered are not legally cognizable defenses. So, like, for example, his motive. A lot of his stuff that he said, for example, for Snowden, goes to his motive, right? He wanted to do it because he thought it was for the greater good, or he thought it was necessary in some way, or he thought whatever he thought, right? That all goes to motive. Motive is not an element of the crime. His intent is an element of the crime, and his intent was to, apparently, based on all relevant information, his intent was to provide the classified information to people that he knew did not have the relevant clearance. So his intent seems clear. His motive is legally irrelevant. One of the things he said, for example, is that he wouldn't be able to offer his defense at trial. Well, his defense is to motive, which is legally irrelevant. He wants to basically argue nullification to a jury. It's not a legally cognizable defense, right? His legally cognizable defenses would fall into two categories: attacking mens rea or attacking actus reus, or attacking the constitutionality of the statute in some way. The statute's invalid, but, no. So those are your options. Attack the statute in some way that's invalid, but no. And then your only other options are attack mens rea, right? I didn't have the intent to transfer it. I didn't have the knowledge that they were unauthorized, or I didn't, in fact, leak the information. He has no apparent legally cognizable defenses. So assuming the government can prove its case, which there's no reason to think that they can't, at least in part based on his own admissions, he's almost certainly guilty. All right. This is the analysis. If you want to say he was morally in the right, then so be it. But it seems like he's clearly in violation of law. All right. Well, how about Julian Assange? Julian Assange's position is completely different. Julian Assange was not provided information, to the best of our knowledge. Julian Assange was not provided information directly by the U.S. government. He was not provided information subject to the National Security Act. He did not agree, but upon receiving that information, to keep the information secret. He was provided the information by a third party who might have been subject, but he's not subject. So his release of the information, if all he did was receive the information, is protected by law. This is in well keeping with other things. A famous case on point, incidentally, would be the case of the Pentagon Papers, where the Washington Post published classified information. And none of their journalists were able to be prosecuted. The U.S. government very much wanted the information not to be published. And very famously, the U.S. government said, well, you can't stop it, because they didn't agree to anything. They're not bound to it. The First Amendment is different as to them, right? It protects them. It doesn't maybe protect the underlying leaker, but it protects the Washington Post. So what would be equally true for the Washington Post would be equally true for Julian Assange. All right, so where the U.S. government is trying to change this analysis is in the nature of the solicitation, right? It wasn't that he merely received the information and agreed to receive the information. The U.S. government wants to try that he solicited the information. He asked for the information. In the first instance, he encouraged, aided and abetted, encouraged to receive the information. The amount of information that's available in the public zeitgeist is insufficient at this time for me to adjudicate in any sort of real sense. It would depend perhaps quite specifically on the nature of what he said. If what he says is just give me any classified information and I'll release it, this, although maybe a solicitation in some grand sense, is not specific enough to reach to a specific solicitation, right? You need something more specific if you're going to get to the material he released. So you would have to show that he made more specific overtures with respect to specific information in order to achieve some sort of solicitation request. The information at this time is insufficient that I've reviewed to form a basis for this. Also, likewise, there is an idea that there is the idea of him encouraging, soliciting, aiding and abetting with respect to breaking into classified information. So Bradley Manning, Chelsea Manning, whatever, Bradley Manning at the time, Chelsea Manning now, not only released information to Assange, but also, it appears, might have had to circumvent some sort of security protocols in order to get the information. He didn't have the information at the time. He was a he at the time, so he didn't have the information at the time. In order to get it, apparently, and he had to apparently break into to circumvent some sort of security mechanism in order to get it. So again, the question becomes, as to Julian Assange, well, what did he do? And the question, and the charge from the U.S. government basically is aided, abetted, assisted, encouraged, and all the rest, right? That he provides some sort of assistance, encouragement, aiding, abetting in the process of breaking into, circumventing the security measures of, or otherwise, whatever, with respect to this information. The nature of Assange's guilt, therefore, is again going to turn on the specifics. What did he do? What didn't he do? What did he encourage, and so forth and so on, right? So there is insufficient information that's available at this time, at least that I've reviewed, to adjudicate Assange. It may well be the case that his conduct is well in keeping with First Amendment protected speech, in the same way the Washington Post was when it came to the Pentagon Papers. Or it may well be that he has crossed the line into actually aiding, abetting, rather than just mere passive receipt. So we'll have to know more before we can sort of adjudicate Assange's liability. But the U.S. government has some theories that are potentially viable depending on the nature of the proof they might have against him. So that is what we know or don't know about Assange at this time. So let's talk a little bit about a different guy who has recently been found guilty with respect to stuff. A CIA programmer, computer programmer, who was behind WikiLeaks Vault 7 cache, found guilty of espionage. So this is exactly like, what did he do and what didn't he do, right? He's a programmer working for the CIA or in connection with the CIA, either way, like he's on the inside. And so his release, his interaction with material is different than Assange's. He's on the inside. So he's comparable to Snowden, who's on the inside. Assange is on the outside. So their factual pictures as a result are completely different. Because, well, at least as well as the law has been developed up to this point. All right. So here's, a New York jury. Let me change the margins on this so it's a little bit easier to read. Okay, great. A New York jury has found former CIA programmer Joshua Schulte, I think, guilty Wednesday, 9 counts of stealing classified documents from the spy agency. right? So theft of governmental secrets, classified governmental secrets. Yeah, he's the one who stole them. He's the one who procured them. In this domain, right? In this domain, stealing and procuring the information is different than receipt of the information because of First Amendment interests, right? Normally, if you steal a thing and you receive a thing, you might very well be equally guilty. So if you're thinking about like stealing a car versus receipt of a stolen car, well, you may or may not be equally guilty of the theft, and even if you're not, you're guilty of receipt of stolen property. So you're usually guilty of something. In the First Amendment context, at least as to this point, when it comes to speech, if all you've done is receive and then publish, the Pentagon Papers case and other cases seem to suggest that you're in the clear. If you did more than merely receive, you might have a different set of problems. If you're on the inside and you're just obtaining the information and leaking it, you have definitely a whole different set of problems. And also, he's on trial for unrelated CP charges, which I can't possibly begin to adjudicate, and faces up to 80 years in prison. He was 28 when arrested in 2018, nearly 6 months after WikiLeaks published the largest trove ever of confidential files on the CIA and agency's history. WikiLeaks might well legally be in the clear, depending on a whole host of factors, as we've tried to discuss, but this guy, not so much. With more than 7,000 pages, millions of lines of embedded code, and several hundred attachments, the document dump that WikiLeaks dubbed Vault 7 detailed how the agency used malware to hack iPhones, Android devices, and Samsung smart televisions of private consumers. Again, if you want to make moral arguments about why this is a good thing, then, fine. I think, there's, on legal arguments, though, the information is protected, it's classified, it's the U.S. government's information, and, we can just keep it simple. It's the U.S. government's property. He took the property, and he gave it to someone else. I mean, that's just theft. We can keep it simple. We can make it more complicated, but on basic level, he took a thing that wasn't his and gave it to someone else that he didn't have permission to give it to. I mean, we can complicate it, but, if you think that, it was for some moral purpose, then okay, but, at base-like principles, it's just kind of theft. All right, so one such covert program apparently exposed in Vault 7 is Weeping Angel, which offers hackers a window in the private citizens' world by way of Samsung smart television. Okay. The espionage tools revealed how the professional groomed CIA hackers and other individuals, including those of a foreign government, engage in training systems and frequently exchange information on how to bypass password protection, antivirus software, and other forms of encryption method with relative ease. I mean, that the CIA is trying to do this should not come as a massive surprise to anybody, right? The CIA is looking for every possible way of obtaining information. I mean, to some degree, that's exactly their job, along with the NSA and the rest of the national security apparatus. And I think the 14 different agencies that there are that deal with national security information, it's hard to keep them all straight because there's so many of them. But to the extent that they're outward looking, foreign looking, this is kind of what they're supposed to do, to a large degree. They're supposed to look for ways to obtain intelligence from foreign assets. So, of course, they're looking for ways to monitor televisions or look at phones or basically any other method that possibly could devise to obtain this information. Right? That's kind of their charter. That's what they're supposed to do. To the extent that they're doing it internally in the United States, it raises different questions, obviously, for Fourth Amendment protections. But then again, our Fourth Amendment only protects us. If you're a foreign entity, and the government wants to spy on you, oh well. That's kind of government spying on governments, or citizens even in their governments. I mean, the government wants to get information from anywhere it can get its hands on it. Such is the tool of espionage. I mean, this is kind of basic, so I none of this surprises me in any way. You could just kind of guess your way into assuming the CIA is doing this, and you'd be right, or at least trying to. Schulte, wearing a black suit and blue-gray tie, remained composed alongside standby counsel because apparently he represented himself. That's why it's standby counsel. He went pro se, which, fun. The U.S. Attorney for the Southern District commended the conviction for what he called one of the most brazen and damaging acts of espionage in American history. Yeah, amazingly enough, the United States makes espionage illegal. So does every other country in the world, by the way, pretty much. So yes, espionage is in violation of the law of the country. So, don't get caught, and don't commit espionage against your own country. See, when you reveal private information of your own country, the country's going to have an issue. You were paid to reveal the secrets of other countries, which, as far as American law is concerned, is perfectly legal. In the laws of their country, much less so. But, you committed an illegal act in the United States, and the U.S. government found out and arrested you, so, yeah. Schulte was aware of the collateral damage of retribution could pose, an extraordinary threat to the nation made public, rendering them essentially useless. To some degree, perhaps. Have a devastating attack on our intelligence community by providing critical intelligence to those wishes did us harm. Even if it did none of those things, it would remain illegal. This is even if it didn't have all these collateral consequences, it would remain illegal. This is classified information generated by the United States national security apparatus. They are generating this information largely, although not necessarily entirely, which raises a whole host of problems, as we learned from Snowden, but they're doing a lot of this fully legitimately. Not all of it, but a lot of it. Legitimately. Their goal and charter is largely to go spy on the world. Find the information out so the U.S. government has it, so it can increase its strategic advantage. All other countries in the world, by the way, are trying to do the exact same thing. This should surprise absolutely nobody. And so the United States government is generating a whole bunch of classified information. So it has the whole bunch of classified information, and then it has information about how it obtained the information, like its secret plans of how it did it, its software, or its methods and operations. So revealing any of that is illegal. If you reveal the information, it's illegal because it's not your information. It was generated by the U.S. government, and if a whistle needs to be blown, there are whistleblower laws, and you have to follow a specific procedure for that. You can't just do whatever the hell you want to. If you reveal sources and methods, that's a problem, because now the bad guys know those sources and methods, and now they'll try to go around those sources and methods, and now you have to generate new sources and methods. So, on the law, it's pretty easy. The government initially tried Schulte for the leak in 2020, but month-long proceedings ended anticlimactically after deliberations with the jury deadlocked on 8 of the most serious counts pertaining to theft and transmission. Perfectly fine. I have no problem with that either. He is absolutely entitled to a jury. Of course he is. I believe in that as much as anyone else. He's entitled to a fair trial. He's entitled to a fair presentation of the evidence. If the government can't make their case, then, sucks to be the government. Just because someone did an illegal thing, the government still has to prove it. If the government can't prove it for whatever reason, then, oh well. That's part of the Constitution too. It's just the law. Everyone has to obey the law, including the government. So it's yeah. Separate from contempt of court and lying to the FBI, 2 minor counts for which the jury found Schulte guilty, they declared a must trial. Well, lying to the FBI can get you some serious time. I'm not sure how minor it is, but okay. Schulte represented himself for the retrial. One wonders why. Seems like a bad idea. And jurors deliberated at the courthouse for 4 days before arriving at a guilty on all counts. So maybe the government's case was weak. Maybe it was weak, or maybe a whole bunch of things. I don't know. I don't know whether or not. I'm just saying that doing it is illegal. Now the jury said he did it, so that's easy enough. Because Schulte faces open criminal counts on CP, a entirely separate issue, held off date of sentencing. Schulte will return to Manhattan Federal Courthouse in 2 weeks for a status conference relating to the CP charges, which themselves carry up to 20 years. As a coder at the CIA in Langley, Schulte himself had helped create the tools. So he was hired in part to create the tools to get the information. Okay, great. Prosecutors said he used a backdoor password to access the CIA's most protected technical secrets on offline servers, then attempted to cover his tracks by manipulating and deleting logs of activity on the sensitive CIA servers. I mean, from baseline principles, this is not particularly complicated, right? His employer had a whole bunch of assets. They're the employer's assets. They control how their employees can use the assets, like every business on the face of the earth, right? You can use these assets, but not these assets. You can use these assets in these ways. You can use these assets under these conditions, right? It's just like any employer telling their employee, hey, I'm the employer. These are my things. I own these things. You're my employee. You work for me. So I get to basically describe reality, like what you can do, when you can do, how you can do it, and so forth and so on. The fact that it's the CIA, I mean, to some degree ups the stakes, I suppose, but on fundamental baseline principles, it's kind of simple. Once again, took a thing that wasn't his, apparently with knowledge and purpose, and then with knowledge and purpose gave it to people that weren't authorized to receive those things. It's just theft. Elevated theft, maybe, but, yeah. His internet history showed that for months, he transmitted the files to WikiLeaks. He repeatedly checked Julian Assange's founded website. He apparently was obsessed to find out if the information published. He could have probably tried to cover his tracks better, but then again, working for the CIA, he probably would know that, the CIA can figure things out. They betrayed him as a maladjusted and discontented employee rather than as a politically motivated whistleblower. There was no misguided idealism here. He did it because he was angry and disgruntled. He felt the CIA had slighted him and disrespected him, so he tried to burn it to the ground. Just FYI, quitting is an option. If you work for the CIA or the NSA or any of them, unless of course you're military, in which case, that's a whole different ball game, but most of these people are civilian, you can just quit. I think it's 5 CFR 512. You can just quit at any time. It's fine. If you feel like the government has slighted you, leaving is an option. Prosecutors deemed him a traitor and accused him of trying to continue to carry out crimes after his arrest by trying to leak additional classified information from prison as part of an information war. But Schulte contested the portrayal, telling jurors he was inspired to serve his country, after the terrorist attacks in 2001, and vowed then and there, as a 12-year-old boy in 7th grade, to do whatever he could to prevent another day like that. Hired by the CIA in 2010, he claims that he worked for the team that helped verify the location of Osama bin Laden before the Al-Qaeda leader was killed. No one ever questioned my loyalty or patriotism. That is until now. On August 24th, about 4 months after WikiLeaks began publishing the Vault 7, but prior to his arrest, Schulte was arrested on charges relating to CP and possession of many, many images. And he'll be tried in the Southern District. So, if he's saying that he's in fact innocent, then, all right, then it's just a question of whether or not there's enough evidence, and there was already one mistrial before, so it seems maybe the government's case is a little shaky, but they convicted him now, and without getting into the details of the thing, I can't really independently assess it. So, I won't speak to the righteousness of his particular conviction, except to say that it appears that process was followed. But if he did what they say that he did, that's illegal. And if he did it, whether he did it for good reasons or not, incidentally, is immaterial. So, it doesn't matter whether he did it because he was frustrated with the government and wanted to see it burned, or he did it because he thought that, the information should be free and thought he was doing the right thing or something. Like, his motive is irrelevant to his intent. The only questions are, did he do the thing? Which in this case would be, releasing the information to WikiLeaks, and did he do it with the right the right mental state? Did he knowingly obtain the information improperly? Did he knowingly provide it to knowingly provide it to parties that were not authorized to receive it? And, and basics, it's not that complicated. So, that's that, kind of. Grace gave $9.99 as a super chat. Well, thank you very, very much. Yeah, and he could have been scapegoated. You're right. I'm not saying that his conviction was proper. I don't have enough information to independently assess it. I don't have enough information to independently assess his guilt or not. I wasn't following it. I just read one article. So I don't know to the degree to which the government has it or not in sort of the evidence. So it's possible that it's some sort of scapegoat or something, but it's possible not. And, a jury did look at this and had 4 days of deliberations, and, he did decide to represent himself, which is always a super move. So I'm going to assume for the moment that this conviction is proper. But I don't mind anyone who wants to have some doubt on this issue because, the government might be playing a bit fast and loose with Assange. I remember reading, when I read the original indictments, on the solicitation charge, it seemed pretty thin. And then I just didn't have enough information to adjudicate one way or another on the assisting charge with respect to the bypassing security. I didn't have enough independent information. But some of the charges from the government when I read this, and this would be like 2 years ago at this point, but some of the charges against Assange looked a little thin. I was like, I don't know, man. I don't know about that one. That seems like maybe you're going to freedom of press territory. But the government might have it. It just depends on the particulars. So we'll see. Yeah. I understand the law is equal. I just wish it applied equally to all. Yeah, you and me both. And the government sometimes breaks the law, sometimes knowingly, and sometimes it's not held to account. And it's very unfortunate. But that's kind of the way of things. They're going to exchange Ghislaine for Assange? That doesn't even really make sense. I don't even know what that means, to exchange her. I mean, she's been convicted in the United States and sentenced in the United States. I don't even know what it would mean to exchange her at this point. I don't even know what that would mean, to exchange Ghislaine Maxwell to the UK. I doubt that. I doubt that very much. Yeah. I guess, also, incidentally, I wanted to just share a bit of personal victory moment, because why not? So, you may or may not remember, because it's been a long time, that yours, Uncivil Law, once received a community guideline strike from YouTube. It was over one of the Capitol Riot videos. It was episode number 29 of the Capitol Riot videos, in which YouTube, in its infinite wisdom, flagged my video as somehow, some way, inciting or encouraging violence, which is ridiculous. I have never encouraged or incited violence, ever. And the entire series is not encouraging, it's exposing. So, obviously, when that was flagged by YouTube for its content violation, I appealed, and I lost my appeal. And YouTube's like, okay, you can never appeal ever again. So I was very sad, and also those community guideline warnings never disappear. Strikes disappear. So if you when you get striked for community guidelines, they last for a while and then they disappear. But that initial warning doesn't disappear, it's forever. And I was very, very sad about this, because I was like, this is unjust, right? I am not encouraging and inciting rioting by reading official DOJ documents and FBI documents and reading official charging documents. This is ridiculous. This video, by the way, is so old that in the video I introduced myself as Internet Law Review. That's how old that video is. Okay, but so this is going back a while now. Well, through mechanisms that I will not reveal publicly, because I don't want to unduly, whatever. That warning has now been withdrawn by YouTube. So things occurred, and I continued to pursue it, and things occurred, and through mechanisms, that warning has now been withdrawn. So I no longer have a community guidelines warning against this channel. So it only took like 2 years, but we got there. So, yeah. Yeah. So, and of course, the thing never made any sense, right? I've even put it in my original appeal. I'm like, I'm a lawyer reviewing official FBI and DOJ charging documents, exposing the people of January 6th, and basically pointing out why they're going to jail. Oh, this also reminds me of a different thing, and I might make a different video about it tonight as well. I think I will, actually, but I'll talk about it now, and then I'll make a different video just talking about it again, because I can. There was AOC, Alexandria Ocasio-Cortez. And Alexandria Ocasio-Cortez made a video recently, Instagram or whatever, in which she is commenting about the events of January 6th. And she is commenting that she notes that various members of the Capitol Police may have potentially let people into the building, and she doesn't know who they are because she doesn't feel like there's ever been an investigation of the Capitol Hill Police. She doesn't feel like there's been a sufficient investigation of what police, of the Capitol Hill Police or otherwise for that matter, might have done things that might have, in some sense, assisted people who were engaging in events of the day. Now, I will note a couple things. First of all, someone said, well, we should get her under oath. We should depose her. We should get this as a sworn statement. She, at least in the video that I saw, didn't say about anything that she observed. Like, she didn't say, I observed these things happening. She seemed to be commenting on things that have come to light as a result of the investigation. So it wasn't, I witnessed XYZ, at least the way I heard it. It was just, this information has come to my knowledge. So she's not, everything she said is not evidence, at least the way I heard it. It's not evidence. You can't get her under oath. You can't get her to testify. You can't get any of these things. She's not offering any evidence. She's not saying, I saw, I witnessed. It seems to be that she's commenting on information that has come to light that we all kind of can see. Various videos that appear to show Capitol Police doing things that would appear to reflect this. Those videos or those images are evidence or not. I mean, their evidentiary value would have to be formally established, of course, at court. But we'll take it as a given their evidence for the moment. But, you know, everything, it's like there's nothing to get AOC to do. Like, so it's like, oh, this is a burn. AOC might have just AOC has opened the door to all these defendants. It's like, no, the door was no more open this afternoon than it was this morning. Like, nothing AOC said made the door more or less open. All the information that's available was already available. If people were going to argue that they were let in or assisted by the Capitol Police or authorized or whatever, that information was already available for them to make those arguments or not. This does not mean that those arguments are legally tenable, but the arguments are available, right? So, like, what AOC said or not really doesn't change the picture. Also, the committee could still subpoena her for what purpose? Watching daily, like, yeah, I guess the committee could subpoena her, but unless she's going to offer evidence of what she saw or what she heard directly, she has nothing of value to say to the committee. Like, the committee why would the committee want her to testify as to videos that she's watched and conclusions she drew from them or not? It's like, it doesn't really go anywhere. If she has firsthand knowledge, then fine, but otherwise it's like, what's the point? You know? So it doesn't really make any sense. Where was I going with all that? Oh, yes. Now, that defense of being available or not to some people does not, of course, mean it's available to everybody. And it doesn't also, incidentally, mean that the defense is necessarily fully available. Because even if they were let into the building, it might not necessarily preclude some of the charges that they're being charged with, right? Whether or not you can be in the building is one element of a charge. It's not necessarily all the charges. For example, the parading and haranguing thing would not necessarily, just because you're let in the building, doesn't mean that you are allowed to be disruptive in the building, right? I can go to the Capitol today. Well, not necessarily because I'm not there, but you know what I mean. I can go to the Capitol today, and the Capitol Police will let me in the building. That doesn't mean, therefore, I can do whatever I want once I'm in there. So the Capitol Police letting people in or not doesn't necessarily nullify all the charges that they're getting, even under the best scenario. Like, it might nullify a trespassing charge, maybe, but we'd have to get into it, because whether or not they were authorized to do so, and it could get complicated. But even if you could get to some of it, it wouldn't nullify all of it. It also would not nullify it with respect to every person, because not every person was let in, right? So even if the defense, to the extent it exists, would have to be brought up by each individual defendant with respect to each individual case. This should not be that difficult a concept. Like, every person and every charge, incidentally, like, you have to consider all these things on their own terms. So every single charge of every single person has to be considered independently. That's a lot of things to consider independently, but that's what courts are for, right? To consider all those things independently. And so just because the defense might be available to some people and some charges does not in any sense mean that it's available to everybody in every charge. Just because, even assuming the premise that one person was let in by the Capitol Police, it may do something for that one person. It does F all by itself with respect to anybody else. One person being let in does not mean everyone was let in. That's ridiculous. And so you'd have to adjudicate these things separately and independently, right? And some of the evidence certainly reflects that people did a lot of things, including letting other people in. So one of the things that sort of was annoying to me from the first outset was, the doors are magnetically locked. The only way that they could is if the Capitol Police open them. I'm like, well, no. We've seen the proof ourselves. We've seen proof of people busting in windows. We've seen proof, because we've covered it on our channel. We've seen proof of people busting in windows. We've seen people going through the windows. We've seen people, once they're inside the windows, opening the doors from the inside. Not Capitol Police. So, some people got in there by busting windows, and the doors are magnetically locked. Well, some people just busted the doors. There does seem to be evidence to that effect. Janelle Vargas says, "Is that your JD in the background?" No, it's. I appreciate it. No, it's not my JD in my background. That is my license to practice before the United States Supreme Court. That's what that is in my background. That's my license to practice before the United States Supreme Court. So, but thank you for the super chat. But yeah, so it's like you have to adjudicate these things independently. And there's a lot of evidence to suggest that for a lot of these people, and none of the cases we saw, at least on their face, would any of these defenses be available. We only covered 50 of 800 of them, but still, none of the defenses would apply to any of the people we saw. So yeah, what Alexandria Ocasio-Cortez, there's a lot of people on the right who seem to be treating this like some coup d'etat that's like a massive exposure to all of Jan 6, but no, it's really not. And her observations are available to anyone and might apply to someone in some situation, but definitely does not apply to everyone in every situation. So yeah, all that good stuff. How's the bar study coming along? Fantastic. I had a nice session this morning, and I'm planning to meet with somebody tomorrow at my house who's also studying for the bar, and it might be an all-day thing, and I'm really looking forward to it. We've got about 10 days left, and we got to really do it. And I'm learning things. So, bar study group, exactly. Yeah, just for the accountability. No live tomorrow. I'm not necessarily saying there won't be a live tomorrow. I am saying that there probably won't be a live until tomorrow evening. So if there's going to be a live, it would be in the evening. It probably will not be in the morning or even in the afternoon. It'll probably be around this time or maybe later. So there might be a live. There just won't be a morning live, unless the world comes to an end or something. In which case, I'll carve it out. But yeah. So how do Texas's laws differ from Virginia? I have no idea, actually, how they differ. And the reason I don't know how Texas's laws differ from Virginia is because Texas, like 23 or 24 other states, have adopted the uniform bar exam. So Texas's bar exam tests on model law, not Texas state-specific law, which has the upside of meaning that I'm basically sitting for the bar in like 23 states specifically, but also means that there's no Texas-specific law. When I took the Virginia bar, long, long ago, there was Virginia-specific law on it. But somewhat ironically, there is no Texas-specific law on the Texas bar exam. Not anymore, because there's the uniform bar exam now. So, how does Texas law differ from Virginia? I have no idea. And I'm not going to learn at any point in this exercise, which is kind of hilarious. I'm taking it in some sort of convention center in Austin. I've got an address somewhere. Hey, Carol, how are you doing? You're not invisible. How are you doing? I see you. Carol, Lucy, you are not invisible. I see you. Oregon included? I have to take a look at the map. Should we try to find the map? You can be a lawyer in Virginia without law school. That's true. You can apprentice. Old school. I knew in the year I was sworn in, one person did it. Let's take a look and see. It's very uncommon, but it is possible. Let's see. Is there a map? Yes, there is. Can I have a map? Yes, I can. Okay. Yeah. All right, great. All right, let's see if I can share the map with you guys. That would be a neat trick. And I'll share you the uniform bar exam map. Virginia is still not part of the uniform bar exam. That's funny. Virginia is still taking. Virginia is still doing it the hard way. That's funny. Can I save this tool? Can I save this image as? I'm having a tough time with this. I will get this. Don't worry. Or not. And worry. Can I print it? I can print it. I'll save it as PDF. Great. All right, so I'll save that, put it in stories. Okay, now I need to load it. Which is somewhere. Great. Okay, so here's a map. Let me make the map a little bit bigger. I can change the margins on the map. Well, not really. We'll just do it with this thing. All right, so this is the uniform bar exam. This has only existed since 2008, I believe, which is the year after I took the bar exam. But here, and so you can see the states with the little star on it have the uniform bar exam, the UBE. So Texas has a uniform bar exam. Oregon is a uniform bar exam. Washington is a uniform bar exam. New York Yeah. Washington, Oregon, Alaska, Arizona, Utah, Idaho, Montana, Wyoming, Colorado, New Mexico, Texas, Oklahoma, Kansas, Nebraska, North Dakota, Minnesota, Iowa, Missouri, Arkansas, Texas, Illinois, Indiana, Iowa, Ohio, Michigan, West Virginia, North Carolina, South Carolina, Pennsylvania, District of Columbia, Delaware, New Jersey, New York, Connecticut, Rhode Island, Massachusetts, Vermont, New Hampshire, and Maine have the uniform bar exam, and the Virgin Islands. And yeah. So, yeah, the first date I think was 2008, which was who? I thought it was 2008. I'm seeing a 2011, 2012, 2016. Let's see, 2020, 19, 11, 17, 19, 17, 21, 23. So that hasn't happened yet. Close enough. 16. So yeah, like the earliest is like North Dakota, 2011. Yeah, something like that. So basically, I'm effectively sitting for the bar exam in like 30 states. Cars in Depth says, why would one need to be in a private organization, the bar, in order to practice law? Well, the bar isn't a private organization. It's a public organization. It's a public organization with restricted membership. But, you know, why do you have to be a lawyer to practice courts? I mean, because, like, there's a lot to know. And, you know. So if I pass the bar, do I have privileges in those states automatically? No. First of all, each state has different requirements to pass. So first of all, you have to pass the threshold of every state's individually. But incidentally, it means that it's hypothetically possible for me to fail Texas and pass some other state, which would be hilarious. Because different states have different admissions. So I would theoretically pass some number of states, maybe some of them and maybe all of them. Or maybe not Texas and others, which is just hilarious. What was I gonna say? But yeah, why wouldn't I be licensed if I passed? Because I have to ask each state individually, and I have to pay fees and file paperwork, and it's a pain in the ass. So that's why. Incidentally, why I wouldn't want to be licensed, so why I wouldn't want to be, is because I have to pay fees every year. So every year I have to pay Virginia, I think it's $250. I have my bar due notice on my table. So every year I have to pay Virginia $250 to continue being a lawyer. Plus I have to do CLE, which is continuing legal education, which is really annoying and boring. So why I wouldn't want to be admitted in every state is because I'd have to write every state a check of like whatever the number would be, and I'd have to maintain my license in every single state by doing whatever the continuing educations are. So it would be a lot. How's the bar not a gatekeeping monopoly guild? It is a monopoly guild. It is a guild. Yeah, it's a guild and it's a monopoly. How's it not? It is. Are you asking me how it's legal? Are you asking me how the guild for lawyers is legal? I think you're kind of answering your own question on that one. How's the guild for legals lawyer? How's the guild for lawyers legal? Well, yeah. In Wisconsin, if you graduate law school, you are automatically admitted in Wisconsin. That's true. Is Wisconsin now a member of the Uniform Bar Exam? No, not yet. Maybe later. Ruth says, so enjoy your mind? Well, thank you. I appreciate that. It's very kind of you. I mean, there's a lot to know to be a lawyer. It's a profession that should be regulated, to be honest. There's just a lot of information. It takes a lot of time and a lot of practice. And it's just a lot of stuff. And I'm learning stuff all the time. Like on my best days right now, I'm scoring 80% on the bar exam, which kicks ass. 80% is a great score. But like, can you imagine like how much people don't know who haven't studied this stuff for years and like all the rest of it? It's just like, it's like being a doctor in the same way. It's like doctors learn new things all the time. They have to continue learning things, and they forget things, and they have to relearn things, and there's a lot of stuff, and it's like, it's just a lot of stuff. So it's not much more complicated than that, really. CPAs? I'll take your word for it. So, it's one of the reasons it's like much easier for me to have a conversation about law with another lawyer. It's because I know that they have a lot of background knowledge, and so like we can talk in shorthand. It's one of the reasons, and sometimes I forget what I know, and I have to remember what people who haven't studied this know. So I try to be a very good teacher and trying to simplify this stuff and stuff, but like sometimes I'll forget like what I know because it's just baked in. At what point did you decide your specialty? I guess when I realized I could take the patent bar, I was like, well, it's just something I should do. It's like, I was like, well, I qualify for it, so I might as well take it. So, All right, I'm going to sign off for now. If I probably won't be on later because I need to do some study, and I'm going to do some study tomorrow, but we'll try to get around to it. I think I'll get at least a 300, 400 on the bar exam. I don't even know what the bar exam is out of. Is it out of 400? I don't even know what it's out of. I haven't worried about it. It's like I don't even worry about what the passing threshold is because it doesn't matter. It's like I just keep studying for it and just learn things. And hopefully it'll be enough. 10 days left to go, So, we may be a little bit shaky on material between now and next Tuesday and Wednesday, depending on time and the rest of it, but it's out of 400. Okay, well, there's information I didn't have. What do you need to pass in Texas? Do you happen to know off the top of your head? It's probably like 180 something, or is it higher than that? I don't actually care. I don't want to know the answer. All right, I'm going to sign off for now before someone tells me. All right, until later, bye.